Decisions made in Washington can affect your portfolio every day. But what policy changes should investors be watching? Washington Wise is an original podcast from Charles Schwab that unpacks the stories making news in Washington right now and how they may affect your finances and portfolio. Listen at schwab.com/WashingtonWise.
This episode is brought to you by LifeLock. When you visit the doctor, you probably hand over your insurance, your ID, and contact details. It's just one of the many places that has your personal info. And if any of them accidentally expose it, you could be at risk for identity theft. LifeLock monitors millions of data points a second. If you become a victim, they'll fix it, guaranteed, or your money back. Save up to 40% your first year at lifelock.com/podcast. Terms apply.
So, Mark, is racial profiling the law of the land now?
With some minor qualifications, Mary, the answer is yes.
Mark Joseph Stern watches the courts for Slate. So earlier this week, when the Supreme Court seemed to give the okay for federal agents to demand citizenship papers based on what people look like, I knew we had to talk.
The White House is high-fiving a 6-3 decision that critics say greenlights racial profiling as ICE agents round up suspected illegal immigrants.
The court's decision was technically about immigration enforcement in Los Angeles. Who could be detained, where, and why. But its implications are huge.
The Supreme Court has now given the green light for law enforcement to profile and detain Angelenos based on their race.
One of the stranger things about this ruling, Mark says, is the way it was made. The Supreme Court technically is not even in session until next month. This decision came out as an unsigned order, with only Justice Brett Kavanaugh explaining his reasoning and Justice Sonia Sotomayor explaining her dissent. It's a little wild when you consider how the courts thought about race in the recent past.
There is precedent that says that someone looking to be of Mexican ancestry cannot, on its own, justify a detention, even if it's near the border. There is precedent that says that race can never be a factor in any decision that the government makes. That was in the recent affirmative action decision from a few years ago.
This all seems to run completely contrary to what the Supreme Court just said.
And just sort of to step back and give a global view, like most fundamentally, the police cannot, in the United States, seize or search you without reasonable suspicion that you've committed a crime. And your race and your language and your occupation have never before been grounds for reasonable suspicion that you are a criminal. Never before until now.
You know, a friend of the show, Gustavo Arellano, who's a columnist over at the LA Times, he's Mexican, and he wrote a column this week that was titled, "I'm a U.S. citizen. I'm always going to carry my passport now. Thanks, Supreme Court." Is that reaction extreme?
Not at all. No, I think that reaction is entirely reasonable. I actually think that most of us should be carrying proof of citizenship now. Frankly, all of us. But those of us who look Latino, and I'm using air quotes here, right? I think the whole concept of this is offensive. But those of us who might appear Latino to the police need to have proof of citizenship at all times.
Today on the show, what the Supreme Court's new racial profiling ruling really means. I'm Mary Harris. You're listening to What Next? Stick around.
This episode is brought to you by Jack Daniels. Jack Daniels and music are made for each other. They share a rhythm in the craft of making something timeless, while being a part of legendary nights. From backyard jams to sold-out arenas, there's a song in every toast. Please drink responsibly. Responsibility.org. Jack Daniels and Old No. 7 are registered trademarks. Tennessee whiskey, 40% alcohol by volume. Jack Daniel Distillery, Lynchburg, Tennessee.
This episode is brought to you by Saks Fifth Avenue. With the weather getting cooler, if you're like me, you're looking around for a couple of new items for your wardrobe, like a new sweater, some cute new kicks. And Saks Fifth Avenue makes it easy to get creative with your personal style and find the best arrivals for fall. I went over to Saks.com to check out what they've got on tap, and I gotta say, what I love about clicking around their website is that every piece looks special, one of a kind, as if you'd walk into the office or a party and instantly grab everyone's attention. All the big brands are there, stuff like Alice and Olivia, you know, the young and trendy stuff. I love that I can see the care in every piece Saks has chosen for their fall collections. Each dress or pant or shoe feels a little bit elevated. So if you want shopping to be fun and easy, head over to Saks Fifth Avenue for inspiring ways to elevate your personal style every day.
I want to break down the details of the case that got us to this point. It's called Nome v. Vasquez Perdomo. It was decided 6-3 on the shadow docket. Tell me about the origins of this case. How did it get before the Supreme Court?
So this case emerged when the Trump administration launched something called Operation At-Large, which was the name for the notorious raids that ICE conducted in Los Angeles and the surrounding area earlier this year. We all saw a video of it. We saw the protests, right? Trump eventually sent in federal troops to assist ICE in these operations.
ICE was like showing up at Home Depot parking lots.
Home Depots, car washes, other places where they felt Latino immigrants congregated. So churches, parks, bus stops, right? All of these common places where there were Latino people. And the official instruction from ICE was to go to these places and find people who looked Latino and spoke Spanish or Spanish accented English and demand that they prove their citizenship on the spot and indiscriminately arrest them. And we saw the video, we saw the pictures, like that's what happened. That's what was happening in Los Angeles. And it stopped because a number of plaintiffs filed a lawsuit saying that this violated the Constitution. The plaintiffs included American citizens who were caught up, who were brutalized by ICE agents, who had assault weapons thrust in their faces, who were told basically, if you can't prove you're an American citizen right now, you could get arrested or worse. And they went to court and said, all I did was be a Latino in public, and I got arrested for it. And that cannot possibly be lawful.
And the lower court sided with those people.
The lower court agreed. The federal judge in this case said, absolutely, that is correct. And she said, to be clear, like immigration officers have really broad powers here. Like no one is doubting that they can do a lot of stuff to profile immigrants, target immigrants and arrest them. But they can't engage in racial profiling. They can't just use somebody's ethnic identity or occupation as the lone basis to arrest them on suspicion of being undocumented.
Yeah, the court barred the government from arresting anyone based on 4 factors, right? Like appearing Hispanic, speaking in accented English, working a particular kind of job, being present at a place where immigrants are known to gather, quote unquote.
Yeah, that's right. Or, accented English or outright Spanish. That was the sum total of this decision. It was a pretty modest decision because, that left a lot of avenues for ICE to target undocumented immigrants, right? To find individuals who had applied for asylum or temporary protected status and had it taken away. Under this order, the government could still, basically barge into their communities and carry them away in handcuffs. The government could try to identify churches that were assisting and aiding undocumented immigrants and go arrest them. They could find hospitals that were treating undocumented immigrants and arrest them in their hospital beds, something that ICE has been known to do. All that the judge said was you can't arrest people because of these 4 simple, innocent traits. That was it. That was what the injunction banned.
And the government appealed to the Supreme Court on an emergency basis. Supreme Court weighs in. Could it have refused to weigh in on an emergency basis here?
So this is sort of contested. I would say yes, in the sense that the Supreme Court could have simply refused to grant this request, right? The Supreme Court could have just said no. Could have said, we are not giving you what you want. We are not lifting this injunction. And the Supreme Court says no to the vast majority of litigants who come before it, right? The Supreme Court turns away like 8,000 cases a year. It traditionally has turned away virtually all of the emergency applications that come to the court. And that was for the court's entire existence up until now understood to be the presumptive response to an alleged emergency. The Supreme Court just says no.
But you're saying some people say they had to take it.
So Brett Kavanaugh, in particular, has been like on this crusade to try to reject everything that I just said. And he's been saying, no. When we don't grant something, that is its own decision with its own repercussions. And so there shouldn't be any kind of thumb on the scale toward non-intervention. We should just jump in and decide anything, anytime we want to, and we should grant relief every time we think that there's any reason to think the lower court's messed up.
So Monday, Supreme Court comes out with this decision. I'm curious what you make of how it came out, because it came out with two statements. Yeah. One from Justice Sotomayor, one from Justice Kavanaugh. What did they tell you about how the Supreme Court reached its decision? Well,
very little, actually, because I'll correct you just slightly. I mean, it was really sort of three statements, quote unquote. The full court, the majority, issued the order that carries the weight of the law, saying we are lifting this injunction that prohibits racial profiling in Los Angeles until further notice. That was the only aspect of this like 30+ page mess that actually carried any legal weight. Then we had Brett Kavanaugh's concurrence, in which he explained his vote or attempted to explain his vote to the public.
But he's only explaining himself.
Only himself.
Not what the other justices, the other 5 justices who ruled alongside him.
Correct,
believe.
Because nobody signed on. So the other 5 justices could have completely different views. We just have no idea. And then we have Justice Sotomayor's concurrence, which was joined by Justices Elena Kagan and Ketanji Brown Jackson, which is a vigorous response to both the government's arguments and Justice Kavanaugh's arguments. And so I guess what I would say is there's like a hole at the center of all this, because normally when I come on your show and we're talking about a Supreme Court decision, we have a decision to talk about. But here we don't know what the Supreme Court thought. I mean, the government raised very different arguments as independent bases for a decision on its behalf. And we don't know which of those arguments the full court ultimately accepted because it didn't bother to tell us.
Let's talk about what we do know. So if you look at Justice Brett Kavanaugh's concurring opinion, he basically said ICE agents are just doing brief investigative stops. Those are his words.
Yeah.
And that, they promptly let people go if they are found to, say, be a citizen or have a right to be in this country. And to me, this was a strange position to take, given that the litigants before him were people like citizens who had been caught up
right.
in a drag. Like, that's actually completely contrary to what he's saying here. So explain his point of view and whether you think the facts support it.
So let me just quote. He writes, "As for stops of those individuals who are legally in the country, the questioning in those circumstances is typically brief, and those individuals may promptly go free after making clear to the immigration officers that they are U.S. citizens or otherwise legally in the United States." That statement is entirely false, and it is disproven by the factual record amassed in this case by the district court, which found that these stops are not, in fact, brief. They are frequently drawn out and quite often violent, and the individuals cannot promptly go once they, quote, make clear that they are citizens. They have to prove it. And not everybody in this country goes around with their passport or their real ID in their back pocket to prove that they're citizens. So just factually speaking, what Kavanaugh's saying here is false. It is just not aligned with the reality on the ground. And so he is, I think, radically downplaying what ICE is doing in the field in order to make the Supreme Court's intervention look less evil than it actually is.
And you write about Justice Sotomayor and what she said in her opinion, and how she writes in a plaintive tone that you find her using in very specific circumstances. Do you want to talk about what she says here?
I mean, this is a tone that Sotomayor uses when she's speaking from a place of personal sorrow, I think. And when she's speaking as the court's only Latina justice, she is trying to force the majority to reckon with the unconscionable racism that it has just unleashed. And she has this line where she says, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job, rather than stand idly by while our constitutional freedoms are lost. I dissent." That reminded me a lot of one of her most famous dissents in a case almost a decade ago now, where the Supreme Court greenlit basically a similar kind of racial profiling against Black people and allowed for stops and searches based on very scant evidence, where she had this sort of cri de coeur where she said, this is extinguishing all of our liberties and all of our freedoms and opening the door to mass racial profiling. And in that dissent, she basically said, I get why my colleagues don't see this because they don't have to deal with it. But I grew up as a poor Latina in New York City, and I know what this is like. And it is horrible and soul-crushing. And I felt that she was injecting some of that spirit into this dissent and maybe was trying to help some of her colleagues see what they are unleashing on the ground here. But of course, it was to no avail because the dissent is still just a dissent.
We'll be right back after a quick break.
Comcast is committed to bringing access to the internet to all Americans, including rural communities across the country, like Sussex County, Delaware.
We were being left behind. Everybody around us seemed to have internet, but we did not. High-speed internet is one of those good things that we needed to help us move our farming, our small businesses, our recreation forward.
Learn more about how we're bringing our next-generation network to more people across the country at ComcastCorporation.com/investment in America.
Well, I was down on my last dollar and then I started saving because the bank said fiscal restraint is what you're craving. So I put my earnings in a high-yield account. Let the savings compound and the interest mount. I'm optimizing cash flow, putting debt in check. Now time is my friend and not a pain in the neck. And we've got a little cash to rebuild the old debt.
Boring money moves make kind of lame songs, but they sound pretty sweet to your wallet. PNC Bank. Brilliantly boring since 1865.
Ford was built on the belief that the world doesn't get to decide what you're capable of. You do. So ask yourself, can you or can't you? Can you load up a Ford F-150 and build your dream with sweat and steel? Can you chase thrills and conquer curves in a Mustang? Can you take a Bronco to where the map ends and adventure begins? Whether you think you can or think you can't, you're right. Ready, set, Ford.
We noted that this opinion, it's on this quote-unquote shadow docket, this emergency docket. It means it's preliminary, right? It's not permanent?
That's correct. So this is another Brett Kavanaugh thing. He wants us to call it not the shadow docket, but the interim docket, because he says these are interim decisions. We're just deciding what's going to be the law for the interim until this case reaches us fully on the merits. So all that's happened here in theory is that this injunction has been set aside. The case will continue percolating in the lower courts. But in the meantime, the plaintiffs will not have the protection of that court order that had prevented the government from racially profiling people.
Yeah, the fact that this was on the shadow docket, it's interesting to me. When I saw the reaction to this decision, it felt like people were upset about the racial profiling, but almost like a whole group of people were more upset about the shadow docketness of this. Is that fair?
I think so. I mean, because in part it's so unusual or supposed to be unusual. Like the court does things through regular order. The court does things in a very deliberate way. It has control over its own docket. Normally it hears cases that have percolated through the lower courts, decides them after full briefing and oral argument on the merits. It has written, signed opinions, right? But under Donald Trump, anything that the White House says is an emergency to the Supreme Court. And so they step in and give a big win to the administration without explaining themselves. And that is very disturbing because, as I think I've said on this show like a million times now, the Supreme Court earns its power through its legitimacy. And it obtains its legitimacy by explaining itself and showing its work. And yet again, we have the Supreme Court radically upsetting the law in favor of Donald Trump without even bothering to show its work.
You said that Brett Kavanaugh is something of a fan of the shadow docket or the emergency docket, even though he wants to call it the interim docket.
It's not going to happen, by the way. Stop trying to make it happen, Brett.
Stop trying to make fetch happen, Brett. I guess I wonder, like, if I had an emergency appeal, could I go and Brett Kavanaugh would be like, well, of course, we'll listen to you. You have an emergency, Mary Harris.
No. This is another thing Justice Sotomayor has pointed out in a different dissent. There's one party that gets the benefit of the shadow docket over and over and over and over and over and over again. And that's Donald Trump, the Trump administration. Everybody else, as a rule, still has to wait in line. There are occasional exceptions, but they're very, very, very rare.
I guess you could argue it's presidential privilege. Like, there have to be some privileges that come with the job?
I mean, you could, except that the Supreme Court repeatedly refused to grant Joe Biden's administration relief over the shadow docket. I mean, for 4 years, right, the Supreme Court allowed nationwide injunctions against the Biden administration to stand and refused to halt them on the shadow docket. 6 months into the Trump administration, the Supreme Court has taken away nationwide injunctions, and now it is using the shadow docket like basically every week to assist Donald Trump in his agenda.
So how often has the Trump administration come to the Supreme Court looking for emergency relief? And then how often have they gotten it?
So the Trump administration has asked for emergency relief about 24 times since January. The court has granted it about 20 times, depending on how you count.
That means ruled in Trump's favor?
Yes. Given Trump what he wanted about 20 times. And that is fundamentally altering the law in ways that lower courts cannot possibly keep up with, especially when SCOTUS doesn't even say why it is ruling for Trump.
Yeah. I want to talk about why the shadow docket is problematic for the judiciary.
Yeah.
Because I feel like there's a political argument that it's problematic and that, like, you have a conservative court taking up conservative issues from a certain person, being Donald J. Trump. But there's something else, too, which is the Supreme Court is atop a whole system of judges who make decisions and rely on the Supreme Court for precedent. So having so many shadow docket decisions, if you're like a nice little judge somewhere in California or Utah, how do you interpret what they're saying, and how are you seeing them grapple with that now over the last year?
Oh, I mean, if you're a lower court judge, you're totally screwed. You have no idea what to do. It's really bleak out there for them. And I know, the tiniest violin for life tenured federal judges. But I actually do feel for them, because this has been ensnaring not just like liberal judges, but like Republican appointed judges who are trying to figure out what the law is when SCOTUS changes it every other day. And they're getting increasingly desperate and making these appeals saying, like, please just tell us what to do, because the Supreme Court won't lay out the rules of the road under Trump 2.0. They won't just say, this is what you do now. They're just issuing these cryptic, unexplained orders and leaving lower court judges in total darkness. And so that has prompted some judges to actually start pushing back.
Like, say, I'm not going to implement this shadow docket decision, or what?
No, so not quite that defiant, but like the Supreme Court is not only refusing to give this kind of guidance to lower court judges, they're also scolding lower court judges when they can't read the Supreme Court's mind. So the Supreme Court will do something cryptic and mysterious. Lower court judges will be like, we don't know what this means. We're just going to keep applying the actual precedent until told otherwise. And then the Supreme Court will come down like a hammer on those judges and say, how dare you apply the actual precedent? We wanted you to divine the true meaning of our tea leaves. And so we've seen like Justice Gorsuch and Justice Kavanaugh scolding, reprimanding district court judges for applying real precedent and not like understanding the true secret cryptic meaning of shadow docket decisions. And that has led to this kind of cycle where other judges are kind of standing up for themselves and saying, hey guys, like, I don't think it's really helpful to spank us for not being able to read your minds, because at the end of the day, if you don't show your work, then we don't have anything to work off of ourselves.
What does all of this mean for the actual case we're discussing now about racial profiling? Like, I'm thinking about all sorts of people who have accused the Trump administration of racially profiling, and that's like why I was detained as an American citizen or a Puerto Rican person or something. Do these people just not have a case anymore?
So in theory, Mary, the answer to your question is that someone who is racially profiled by ICE, who is brutalized by ICE, who is treated unconstitutionally, should still be able to go into federal court and sue the officer who violated their rights, except for the fact that ICE, CBP, immigration agents, as a rule, cannot be sued for violating people's rights. The court has allowed for the possibility that there are extremely narrow instances in which there might be a civil suit, but almost certainly not against immigration agents.
Huh. So, people are really stuck here.
Yeah.
Do we know when this case will actually be permanently decided?
No, we don't. And it may never be, because what could happen here is that the plaintiffs could just drop their case. The plaintiffs could simply say, seems like we're going to lose. We don't want to push this any further.
See which way the wind's blowing.
Yeah.
Might as well get out of here.
Yeah. That is a real possibility. The court could also, the district court could also say, I see the way the wind is blowing, and rule against the plaintiffs, and the plaintiffs could just give up. Everybody could just give up. I mean, a lot of these shadow docket cases, even though Kavanaugh wants to say they're interim and that they're just like temporary, a lot of them just end up fizzling out after the Supreme Court intervenes because everybody sees where it's going to go, and there's no need to litigate this all the way through to a catastrophe.
You know, this case about racial profiling, it's interesting to me because I think you could argue that racial profiling happens all the time. And it really makes me wonder, like, how big of a deal is this decision in material terms on the street? Like, why is it important for individuals living their lives when this is potentially just putting like a thumbs up on a practice that would have been occurring anyway? That may be a grim way to put it.
So I think it's a really important question. And I would say that even though racial profiling absolutely occurs every day by, beat police officers, by sheriffs on the highway, like we know that it happens, it is still fundamentally different for the chief immigration enforcement agency to essentially announce that it is envisioning America as a racial caste, wherein Latinos or anyone who appears to be Latino is automatically suspect, is a second-class citizen. That's a term that Justice Sotomayor uses, second-class citizenship. And anyone with this particular physical appearance or, who speaks this kind of language, they have to prove themselves at all times. They have to be ready at any moment to produce sufficient documentation to show that they belong here, because presumptively they don't. And we, the immigration officers, have a right to brutalize them and treat them in all kinds of horrible ways until they prove that, and sometimes even after they prove it. And that just seems so fundamentally contradictory to our Constitution that for the Supreme Court to bless it, and to bless it silently, strikes me as a real turning point in how we conceive of freedom and equality under the law in a dark and disturbing way.
Mark, thanks for coming on the show.
Thanks, Mary.
Sort of. Thanks for leading us into darkness. Thanks for accompanying me on the road to hell.
Yeah.
Mark Joseph Stern is a senior writer covering courts and the law for Slate. He's also the co-host of our podcast, Amicus. And that's our show. What Next is produced by Elena Schwartz, Rob Gunther, Anna Phillips, and Madeline Ducharme. Paige Osburn is our senior supervising producer. She oversees What Next TBD, too. Mia Lobel is the head of audio at Slate. Ben Richmond is the senior director of podcast operations. And I'm Mary Harris. You can go track me down on Blue Sky. I'm at Mary Harris. Thanks for listening. Catch you back here next time.
This episode is brought to you by Saks Fifth Avenue. With the weather getting cooler, if you're like me, you're looking around for a couple of new items for your wardrobe, like a new sweater, some cute new kicks. And Saks Fifth Avenue makes it easy to get creative with your personal style and find the best arrivals for fall. I went over to Saks.com to check out what they've got on tap, and I gotta say, what I love about clicking around their website is that every piece looks special, one of a kind, as if you'd walk into the office or a party and instantly grab everyone's attention. All the big brands are there, stuff like Alice and Olivia, you know, the young and trendy stuff. I love that I can see the care in every piece Saks has chosen for their fall collections. Each dress or pant or shoe feels a little bit elevated. So if you want shopping to be fun and easy, head over to Saks Fifth Avenue for inspiring ways to elevate your personal style every day.
Doug. Limu and I always tell you to customize your car insurance and save hundreds with Liberty Mutual. But now, we want you to feel it. Cue the emu music, Limu.
Save yourself money today. Increase your wealth. Customize and save, we say.
That may have been too much feeling.
Only pay for what you need at LibertyMutual.com.
Liberty, 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 liberty.
Savings vary. Underwritten by Liberty Mutual Insurance Company and affiliates. Excludes Massachusetts.